5 seconds to go. Start. As against the above circumstances, there are various circumstances as pointed out by the defendant which favor the genuineness of the sale. In addition to Exhibit A1 sale deed, Exhibit B17 sale note was executed regarding the furniture and other equipments in the theatre. This probabilizes the execution of Exhibit A1 sale. According to the plaintiff, the execution and registration of Exhibit A1 did not take place at the sub-registrar's office. She was made to affix signatures while she was at the ground floor of the building. However, the sub-registrar or the document writer have not been examined. The document writer is the same person who executed sale deed in respect of the other two items, item 1 and 4, that belonged to the sisters under the partition. Though in paragraph 3 of the plaint, it is alleged that the brother of the plaintiff's husband accompanied the plaintiff to the SRO, he has not been examined. The plaintiff, who is said to have been defrauded, has not stepped into the witness box. Though under section 120 of the Indian Evidence Act, the husband may be a competent witness to depose on behalf of wife in the nature of the allegations as made, the plaintiff was a vital witness and her non-examination looms large. After the observations aforesaid, the High Court expressed that the evidence necessary for proper determination of the suit had not been brought on record and that the evidence on record was insufficient to arrive at a proper finding in favor of or against the sale deed. For these observations, the High Court considered it appropriate that the parties be given an opportunity to adduce further evidence and the matter be considered afresh. The High Court concluded on the matter with the following observations and directions. From the above, I notice that evidence necessary for a proper determination of the suit has not been brought on record. The evidence on record is insufficient to arrive at a proper finding in favor of or against Exhibit A1 sale deed. Material witnesses have not been examined. No evidence has been brought in with regard to passing of consideration. In the circumstances, I am of the opinion that it would only be appropriate if the parties are given an opportunity to adduce further evidence and the matter be considered afresh. The decree and judgment in OS 293 of 2012 is to be set aside and the suit remanded back to the trial court for disposal de novo. In the result, RFA numbers 96 of 2012, 827 of 2010, 238 of 2014 are dismissed but without cause. RFA 247 of 2014 is allowed. The judgment and decree in OS 293 of 2013 is set aside and the suit is remitted back to the trial court for disposal de novo after affording opportunity to all the parties to adduce further evidence. Parties to appear before the trial court on 24th July 2019. assailing the aforesaid judgment and order, dated 28th June 2019, learned counsel for the appellant has strenuously argued that want of production of sufficient evidence had been a failure on the part of plaintiff respondent number 1 to prove her case, but this failure on her part cannot be a ground to put the matter into another round of proceedings in the trial court. It has also been submitted that the High Court ought not to have remanded the suit for a fresh trial while requiring the parties to adduce further evidence, because neither any ground was pleaded nor any relief was sought to that effect. Stop.